having her here, talk to her, disagree with her, and so on and so on and so forth. She got a PhD in 2021 from the LSE. She works on a range of topics in philosophy of science, robustness, probability. She does work in the foundations of statistics, the philosophy of statistics as well. And she has done a lot of work on climate science. She has published various papers, including in Synthèse. And today, Margherita will be talking about probabilism under scrutiny, grappling with the weight of the data. How is yours?
Okay, let's start. Probabilism, I don't know how to pronounce it, but the philosophical view according to which the role of probability is to capture degrees of belief, support, information, or possibility about hypotheses, has been gaining considerable traction across a great variety of disciplines: epistemology, risk assessment, decision theory, ethics, psychology, data science, intelligence law, and statistics, to name a few. Despite its growing prominence, a current concern arises amidst its ascendance. This concern revolves around the idea often attributed to Keynes that probability under this role seems unable to capture something epistemically important about the evidence, namely its amount, completeness, or weight. This concern has cropped up in many areas. In formal epistemology, for example, there have been numerous attempts, albeit relatively unsuccessful, to find a satisfactory indirect measure of this so-called weight of evidence. In decision theory, this concern has sparked great interest in alternative decision models to the orthodox expected decision theory. For instance, both Hill and Bradley advocate for decision model that accommodates imprecise probabilities alongside ordinal confidence judgments, arguing that this model can effectively capture the distinction between the weight and other aspects of the evidence. Within the risk assessment literature, many have argued that against solely relying on probabilities to describe risk, as Alvin puts it, probability can be based on more or less strong knowledge. Keynes is not cited here, but he might as well have been. Recommendations have also been made on how to enhance the communication uncertainty by institutions such as like the IPCC, with the understanding that since the weight of evidence is an epistemically important notion, IPCC uncertainty communication should account for it somehow. In this talk, however, I will narrow my focus to discussions concerning the so-called weight of evidence within evidence law scholarship and the broader philosophy of legal proof. Since this area in particular has been a significant activity and debate surrounding this concept, offering rich philosophical insights that merit thorough exploration. The outline of this presentation is as follows. I will begin with a brief overview of legal probabilism, and I will discuss some cases that have raised doubts about the ability of probabilistic interpretations of standards of proof to adequately capture the weight of evidence, thereby questioning the purely probabilistic nature of standards of proof. I will then go all the way back to what Keynes had to say about the weight of evidence. We will see that not only was Keynes highly perplexed about its relevance for decision-making, but he also believed that any attempt to directly measure the weight of evidence or compare the weight of distinct evidential sets would be bound to fail in most cases. I will then evaluate two drastically different approaches adopted by proponents of legal probabilism in their efforts to tackle the concern that probabilistic interpretations of some proof seem to fail to adequately reflect the weight of evidence. The first approach is to essentially assume that legal probabilism must be right, and hence any concerns that may arise due to the slight weight of evidence and any probabilistic judgment should simply be dismissed as irrational. The second approach is to argue that the weight of evidence is indeed a crucial element in the burden of proof. However, as long as weight has been practically optimized, the probabilistic measure is still the best basis for rational decision-making. I will then argue that both strategies fail to offer an epistemically satisfactory response to the concern stemming from the weight of evidence, and that we shouldn't be surprised by this because they're bound to fail. I will then propose Gardiner's recent account of a relevant alternative framework for interpreting legal standards of proof as a promising alternative to legal probabilism. And finally, I will argue that this framework helps illuminate the ongoing debate surrounding the role of probability in inference at the heart of the so-called statistics wars that, as Deborah Mayo observes, reflect disagreements on one of the deepest, oldest philosophical questions: how do humans learn about the world despite threats of error due to incomplete and variable data? Okay, so currently a legal system employs 3 distinct standards of proof. The toughest standards, beyond a reasonable doubt, is used in criminal trials, while the most lenient standards, preponderance of the evidence, is applied in the majority of civil trials. Somewhere in the middle lies the clear and convincing evidence standard, especially prevalent in civil cases involving citizenship or child custody disputes. But how should we interpret these standards? Well, judges haven't exactly been throwing roadmaps on this issue. However, according to a widely held view, known as legal probabilism, epistemic justification is a matter of probabilistic likelihood given the evidence. And hence the legal system ought to be governed by probabilistic standards of proof. In particular, on this view, a claim is epistemically justified if it meets a threshold of probabilistic likelihood given the evidence. So if given a body of evidence, claim P is more likely than claim Q, this means that P is more epistemically justified than Q by that evidence. Hence, according to legal probabilism, the standard proof should be interpreted probabilistically. This would be done in terms of satisfactory, say 0.5, for probability for preponderance of the evidence, 0.7 for clear and convincing evidence, and 0.9 for beyond a reasonable doubt, or it could also be done in terms of imprecise probability. But in any case, the exact interpretation of the various standards of proof doesn't really matter for what I'm going to argue in this talk, so we don't really have to worry about this. A common concern that has been raised against legal probabilism in evidence law scholarship and the broader philosophy of proof is that probabilistic interpretations of standards of proof fail to adequately reflect the quantity, completeness, comprehensiveness, or the weight of evidence. And in light of this concern, many hold the view that standards of proof cannot be purely probabilistic. Much of the discussion of weight is focused on hypothetical cases where a slight body of evidence appears to provide a strong measure of probabilistic support, and yet the intuition is that the evidence in those cases would lack sufficient weight to constitute legal proof. One class of cases that is much discussed is one in which the only supporting evidence is some sort of base rate evidence. Consider, for instance, this hypothetical civil case. A pedestrian is negligently run down by an identified hit and run bus on the route where the accident happened. The blue bus company operates 80% of the buses. There's no additional information to determine the company to which the bus belongs. Now, in the literature, it's often assumed that in this hypothetical case, one is entitled to infer from the mere fact that the blue bus company operates 80% of the buses, that the probability that the bus belongs to the blue bus company is 0.8. I certainly share Deborah Mayer's concern that epistemologists and probabilists are often a little too happy with the crude induction from 8% of A's have been observed to be B's to infer that the probability that specific A is a B equals K. However, let's just suppose, as many probabilists are more than happy to, that the evidence in this case licenses a relatively high degree of credence, a probability of 0.8, in the hypothesis that the bus was blue. And this satisfies the civil standards of proof, requiring a preponderance of probability. However, many, including me and maybe you, think it would be appropriate to find the blue bus company civilly liable in this case. This example is actually loosely based on a real life lawsuit, and even though the real life cases do not actually involve any statistics or base rates, the plaintiff did introduce evidence sufficient to show that the defendant's bus line was the only one chartered to operate on the street where the accident occurred. Affirming the direction of a verdict for the defendant, the court observed the most that can be said of the evidence in this case is that perhaps the mathematical chances somewhat favor the proposition that a bus of the defendant caused the accident. This was not enough. Consider another hypothetical criminal case that has been discussed a great deal. 100 prisoners exercise in the prison yard, 99 prisoners together initiate a premeditated attack on a guard. Security footage reveals one prisoner standing against the wall, refusing to participate. There is no evidence indicating he refused to participate. The prison officials decide that since for each prisoner it is 90% likely that they're guilty, they have adequate evidence to successfully prosecute individual prisoners for assault. The intuition here is that it's more than reasonable to doubt any particular piece of skill, calling Jimmy. And yet, according to a probabilistic interpretation of legal standards, and under the assumption that the evidence in this case licenses the credence of 0.99, that any particular prisoner is guilty, there doesn't seem to be any good reason not to declare Jimmy guilty beyond a reasonable doubt. I think the probability that Jimmy is innocent is as little as 1%. The plan has been expressed about the slight weight of evidence in another class of cases in which the available evidence is not but nonetheless of weight. Consider, for instance, sexual assault cases where the complainant has delayed complaint for many years because of the delay. The evidence available to the court may be very slight. In the intervening years, records will have been lost, the opportunity for medical or forensic examination will have passed, leaving the court with little more than the complaint's allegations and the defendant's denials. While the available evidence is not statistical, it seems of low weight, and according to Hammer raises similar issues to cases such as Blue Bath and the this is what Hammer says. It will often be difficult for the complainant to win the battle of credibility decisive enough to satisfy the criminal standard of truth. However, the lack of weight of the prosecution case adds a further obstacle. In the leading Australian decision, Longman versus Dean J observed that the evidence of the complainant reads convincingly. It is not surprising the jury accepted her as an honest witness. The same could not be said for the defendant as a witness. But can a conviction rest upon such a slight weight of evidence? The fact remains that the only evidence of the applicant's guilt was the oral evidence of the complainant. There is a marked concern about prosecution proceeding on the basis of such slight evidence. Depending upon the jurisdiction, the prosecution may be blocked by statute. Okay, before we jump into how advocates of legal probabilism have attempted to address the concern that probabilistic interpretations of substantive proof might fail to adequately reflect the weight of evidence and opinion of probabilistic judgment, let's first have a quick look at what Keynes himself, often credited with this notion, had to say about it. Here's a very often quoting passage in Keynes from Keynes' treatise on probability on this notion. As the relevant evidence at a disposal increases, the magnitude of the probability of the argument may either decrease or increase according as the new evidence strengthens the favorable or the favorable evidence. As something seems to have increased in either case, we have a more substantial basis upon which to rest a conclusion. I express this by saying that an accession of new evidence increases the weight of the argument. New evidence will sometimes decrease the probability of an argument, but it will always increase its weight. Now, Keynes is all about logical probabilities. According to this viewpoint, probability represents a logical relationship between some premises and a conclusion. So the truth of the premises entails some degree of rational belief in the conclusion. That's why he's talking about the probability of an argument in this quote. Although this way of thinking about probabilities isn't as popular these days, we can still grasp the idea of the weight of an argument without necessarily buying into the specific interpretation of probabilities. So, according to Keynes, an argument for premises E to a conclusion H not only has a probability, but also a weight. However, while this passage is often cited to hint at Keynes' idea of the weight of argument, what exactly this concept consisted in, according to Keynes, is not entirely clear. As noted by Runde, one can discern two conceptually distinct notions of the weight of an argument in Keynes' treatise. According to the first notion, the weight of an argument depends on the amount of relevant evidence in its premises. Under this view, an argument's probability is entirely independent of its weight. And also, under this view, it also follows that adding relevant evidence to an argument's original premises always increases its weight, regardless of whether the new argument's probability is higher, lower, or the same as that of the original argument. Can we compare the weight of two arguments? Keynes himself didn't think so. Indeed, in most cases, he thought it would be impossible to compare the weight of two arguments. Indeed, consider a simple example where we have two arguments. One is from E1 and E2 to H, and the other one is from E1 and E3 to H, where E2 and E3 are distinct. And suppose that E2 is more relevant than E3. Is the weight of P of the first argument greater than so how should we compare the weight of these two arguments? So perhaps is the weight of the first argument greater than that of the second, since E2 is more relevant in 3. As Cohen convincingly argues, the answer is no, since this would lead one into a paradoxical situation in which the order in which the different premises were stated would affect the weight of an argument. Does it follow from this that the two arguments should be given equal weight? The answer is again a decisive no, since assuming the equal weight relies on accepting what Cohen calls the principle of equivalence, which says that the members of different families of predicates enhance the weight of an argument equally when they enter relevantly into its premises. As Cohen argues, this principle is plausible as long as we restrict its application to primitive predicates in some appropriately tailored language system. However, as Cohen remarks, this will introduce a substantial element of linguistic convention into the assessment of weight. The weight of an argument would depend not just on facts about probabilistic relevance, but also on which predicates were chosen as primitive, and therefore as having no non-trivial entailments. Hence, unless there is a reason in a particular area of inquiry to suppose that the primitiveness or non-primitiveness of a predicate is unambiguously determined by the facts rather than convention, it looks as though the principle of equivalence cannot be rescued. If the principle of equivalence really cannot be rescued, this also means that there is no natural unit of weight, and the prospects of any non-arbitrary system for measuring weight are very poor. Hence, there is no sense in which we can measure the weight of an argument. All we can do is compare the weight of distinct arguments, but as the example just discussed illustrates, even this comparison would not be possible in most cases. Leaving aside considerations of measurability and comparability, there is another important question. Why should we care about weight from an epistemic perspective? Is it really the case that when faced with an argument with greater weight than another, we always have a substantial basis, a more substantial basis upon which to rest the conclusion? This brings us to another conception of the weight of an argument, which Keynes mentioned in his treatise, and which consists in a substantial departure from the first conception. According to this exception, the comparison of the weight of two arguments turns upon a balance between the absolute amounts of relevant knowledge and of relevant ignorance, respectively, and thus depends on the degree of completeness of the information on which probability is based. Although this is a different concept of the weight of an argument, Keynes never says much about it, nor does he acknowledge the distinction in the first place. Under this second conception, I very briefly mentioned, simply comparing the amount of relevant evidence in the premises of two arguments is no longer enough, because to compare the weights. To illustrate this shift, Fidupis offers the following metaphor. If I tell you that I've covered 20 miles, you cannot say if I've come very far in my journey, but if I tell you my final destination, you can tell if I am at the beginning or at the end of my journey, or if I'm almost there. In the same way, the absolute amount of evidence one has already acquired the first definition of weight does not reveal how far one has come in the learning process. But if one knows how much information is relevant to the position H, one can say whether the evidence acquired so far is relatively scanty, complete, or simply sufficient to make a decision. This is because no evidence is itself scanty or complete in the same way as no place can be intrinsically distant. While this metaphor provides an intuitive way to grasp the difference between the two conceptions of weight, it remains unclear whether the second conception of weight is a meaningful concept. Its validity hinges on the possibility of defining relevant ignorance, and despite several attempts by several scholars to tackle this issue, there's no denying that the second conception of weight is significantly more elusive than the first conception. Furthermore, comparing the weight of different arguments under this second conception of weight appears even more daunting than the first. In any case, before wrapping up this very brief overview of what Keynes and commentators have to say about the comparability and measurability of the weight of arguments, it's important to note that while Keynes did believe that the decisions should be influenced by both the probability of an argument and its weight, he himself very much struggled to understand how these factors were meant to interact. This is what he writes. In the present connection, the question comes to this. If two probabilities are equal in degree, ought we, in choosing a course of action, to prefer that one which is based on a greater body of knowledge? The question appears to me to be highly perplexing, and it is difficult to say much about it. But the degree of completeness of the information on which a probability is based does seem to be relevant, as well as the actual magnitude of the probability in making practical decisions. The nullis maxim that in reckoning a probability we must take into account all the information which we have, even when reinforced by Locke's maxim that we must get all the information we can, does not completely seem to meet the case. If, for one alternative, the available information is necessarily small, that does not seem to be a consideration which ought to be left out of account altogether. As I will argue later, Keynes struggled for good reasons. But for now, let's quickly turn to what the Bayesian has had to say about Keynesian weight. So, a highly influential idea that goes all the way back to Jeffrey and that reemerges again and again is that although the weight of evidence may not directly influence the agent's credences, it does impact the resilience of the credences. However, as Hammer points out, this idea is usually motivated with examples in which the aim is to estimate the objective probability of a hypothesis and where one can rely on the statistical concept of confidence intervals. This is what Hammer says. If, for example, there is a mixture of red and white balls in an urn and we're interested in the probability of drawing a red ball, we can estimate this by repeatedly drawing balls from the urn and noting the frequency of red balls. As the number of draws increases, we can place greater confidence that the true ones lie somewhere close to the estimate, and this will be reflected in the narrowing of the confidence interval. With 5 red balls in 10 draws, the 95% confidence interval is 0.5 plus 0.3 for 300 balls. Red balls in 600 draws, it is 0.5 plus 0, plus or minus 0.4. Both sets of data give rise to probability assessment of 50% that the next ball will be red, but the assessment based on the larger data set appears to provide a firmer assessment. This expectation of increased stability flows directly from the mathematics of statistics and probability. Confidence interval weight is calculated from the standard deviation, which measures the variation of sample data from the endpoint. As sample size increases, the standard deviation decreases, and the estimate based on the sample will tend to become more resilient. So, unfortunately, this example, like all the many others that have been discussed in the literature, provides a very poor analogy with cases in which the aim is not to estimate the objective probability of a hypothesis. Consider, for instance, a case in which the aim is to learn whether a particular event did or did not happen. Objectively, the probability that the blue bus hit the pedestrian, that Jimmy participated in a premeditated attack on a guard, and the defendant sexually assaulted the victim is either 0 or 1. So clearly, when we're talking about past events, any probability that's not either 0 or 1 cannot be considered resilient, or at least it might be resilient, but you have no good reason to think that it's resilient since there is plenty of room for it to shift around. What about non-determined future or hypothetical events for which certainty might be deemed to be unattainable? As Hammer notes, the kind of predictions that courts deal with are quite distinct from, say, flipping a coin multiple times. Indeed, because of the diverse body of evidence that courts rely on at trial, there is no reason to think that a fact finder's probability assessment will become more stable over time. Suppose in a wrongful death case, the court was seeking to determine whether without the defendant's negligence, the deceased would have continued working until 65 years. Unlike the repeated draws of a ball from the urn, there is no basis to expect the evidence or the probability assessment it generates to conform to a regular pattern. The deceased smoked a packet of cigarettes a day, suggesting a low life expectancy, but he raced motorbikes, but his diet was extremely good, and so on. Unlike the ball and an experiment where the urn contains a particular proportion of red balls, in this longevity hypothetical, there is no apparent reason to expect the probability assessment to converge towards a particular point of the unit interval as the weight of evidence increases. One might therefore think that in this case, the accumulation of Keynesian weight will concentrate one's credence not about some intermediate level of probability, but rather about one of the polar extremes of 0, 1. However, as Hammer remarks, if the evidence is missing, it cannot be known which way it points. It appears equally possible that the missing evidence would confirm the current factual conclusion as contradicted. The competing possibilities cancel each other out. There is no warrant for the assumption that the missing evidence will point one way rather than the other. The probability calculus captures this logic. The expected probability is precisely equal to the current probability. In James' work, uncovering new facts can lead us to feel either more certain or less certain about our conclusions, depending on what we have learned. New facts may support a previous conclusion, or they may refute them. In other words, there is no reason to think that in this case, an increasing Keynesian weight will result in an increase in certainty. Despite this, however, it has nonetheless been argued that an increasing Keynesian weight can be expected to increase certainty. To understand what this means, recall that certainty in this context is defined as the probability of a proposition or its negation, whichever is greater. So, for instance, according to the definition of certainty, if I assess the probability of the defendant's guilt as 0.2, then I'm 80% certain regarding the proposition that the defendant is guilty. The expected certainty from considering fresh evidence is the average of the level of certainty that will result upon learning the content of the fresh evidence, weighted by the probability that the fresh evidence will have that content. Hammer demonstrates that the certainty expected from considering fresh evidence is bound to be greater than or equal to current uncertainty, independently of any forms the fresh evidence can take. But what is the epistemic relevance of Hammer's results? According to Hammer, these results provide a Bayesian explanation for why fresh evidence should be considered. Hence, the Bayesian can explain the epistemic relevance of Keynesian weight, which is good news because according to him, to deny this would be to express skepticism about the entire fact-finding enterprise. However, is that really so? I think there are a few reasons to doubt this. First, it's important to know that Hammer's results do not show that the expected uncertainty from an increase in Keynesian weight is necessarily greater than the current one. Expected certainty will be greater than current certainty only in cases where there is a possibility that fresh evidence will result in the probability assessment moving to the other side of the 50% level. It doesn't matter for either that way or that way. So, for instance, consider a case in which your prior probability is greater than 0.5, and whatever form the fresh evidence takes, the probability will remain greater than 0.5. In this case, the expected certainty from gathering fresh evidence will be equal to the current certainty. Hence, in all these cases, the Bayesian doesn't seem to have an explanation for why one want to gather more evidence. Second, for this idea to hold merit, one must see certainty, as defined by Hammer, as an unequivocal epistemic good. Yet, what justifies such view? If certainty was related to how close one's belief in a proposition to its truth was to its truth, it would be easy to grant this. But certainty simply represents the probability of a proposition or its negation, whichever is greater, independent of its truth value. It's worth mentioning that Hammer's results can be used to show that the fresh evidence can also increase the expected utility of a decision. However, at best, all this shows is that there can be pragmatic reasons to increase the weight of evidence, not epistemic ones. Third, the explanation for why these results show that one should gather fresh evidence relies on the presupposition that maximizing expected utility is always rational, and I think one could question this too. In light of all these reasons, one could legitimately doubt that Hammer's results are strong enough to provide a satisfactory Bayesian explanation for why one should increase the weight of evidence. Okay, so we're finally ready to have a look at how advocates of legal probabilism have attempted to respond to concern raised by the slight weight of evidence in cases such as Blue-Bath and Prison Yard. I will assess two strikingly distinct responses, and I will argue that neither is epistemically satisfactory. So, according to Hammer, the standard of proof should not incorporate a weight requirement. Missing evidence may influence the fact finder's probability assessment through a spoliation inference, but if evidence has been lost without spoliation, the fact finder should decide the case on the basis of the probabilistic strength of the remaining evidence. The case of the prosecution of plaintiff should not be discounted on account of the slight weight of evidence. But in rejecting a weight requirement in juridical proof, I've acknowledged that weight is epistemically crucial. Probability theory must provide an explanation for why fresh evidence should be considered. And it does. Fresh evidence should be considered because it offers the expectation of increased certainty. This expectation is inherent in the calculus of probability. But here's the problem. This response does not provide any explanation for the discomfort that a fact finder might feel when deciding cases on the basis of probabilistic strength of the available evidence, where the weight of that evidence seems too slight, like in the cases discussed. Instead, it suggests brushing off that discomfort because it's not justified within our probabilistic framework. Basically, it assumes legal probabilism is right from the get-go and says just ignore any discomfort you may have about making decisions based on probability. But for those one already sold on legal probabilism, this argument really fails short of persuasion. Secondly, this response should also be troubling for someone who is sympathetic with Hammer's approach. Hammer's response hinges on the idea that probability theory can explain why fresh evidence should be considered. A crucial one, according to Hammer, since to deny this would be to express skepticism about the entire fact-finding enterprise. However, as mentioned earlier, there are reasons to doubt whether probability theory can actually offer such an explanation. If it, I'll skip this, doesn't matter, but it's particularly troubling in the legal context. Okay. In stark contrast to the previous response, Dale Nance, a professor in law at criminal justice and internationally recognized evidence scholar, argues that the weight of evidence is indeed a crucial element in the burden of proof. In this recent book, The Burdens of Proof, Discriminatory Power, Weight of Evidence, and Tenacity of Belief, he articulates a two-part theory of the burden of proof, according to which One, it is the duty of the court to ensure through a variety of procedural devices that the evidence is reasonably complete, that is, that the Keynesian weight has been practically optimized. And two, it is the duty of the fact finder to determine whether admissible evidence assessed in its appropriate context satisfy a probabilistic threshold criterion of epistemic warrant, one that is determined by public assessment of the relative benefit and cost of accurate and inaccurate verdicts. So in other words, according to Nance, there should be a clear delineation of responsibility. Judges not acting as fact finders on the merit should monitor Keynesian weight using available tools to ensure practical optimization of such weight in the evidence presented by the parties. And the juries should simply assess whether the admissible evidence satisfies the relevant probabilistic threshold of epistemic standard, independently of considerations about the weight of evidence. Now, how should judges ensure a practical optimization of Keynesian weight in the evidence presented by the party? According to Nance, the practical optimization of the weight of evidence depends on several factors. Interestingly, one of these factors has to do with the concept of resilience, of probability discussed earlier. Nance argues correctly that it is a mistake to identify the idea of Keynesian weight with the idea of resilience. The two ideas are distinct, and though there are causal connections between them, the dependence relationships are complex. However, despite all this, the concept of resilience does have some use. The harder it is to shift the probability of interest, that is, the more resilient that probability is, the less is the expected gain in utility of determining which of various possible states of an evidence fact obtains before acting, and so the more rational it is to act on the probability one has at the time. Resilience, therefore, is an ingredient in the rationality of acting on a probability by being an ingredient in deciding whether one should augment Keynesian weight by getting more information before acting on one's assessed probability. This connection places resilience in its proper place. In the legal context, it is a component part of the decision by the court whether the case is right for submission of the dispute for decision by the fact finder. Other factors include the cost of the acquisition of further information, the cost of the additional evidence, and the extent to which the probability falls below or exceeds some threshold of decision. Now, Nance's attempt to account for the weight of evidence in standards of proof stands out as the least conceptually troubled compared to previous ones. For instance, earlier approaches often equated the weight of evidence with resilience, an assumption that at least Nance rightly dismisses. However, Nance's requirement of practical optimization of Keynesian weight is epistemically, in my view, epistemically unsatisfactory, since it entails that whether one is justified to accept a claim depends not on pragmatic factors that have nothing to do with the nature of the evidence at one's disposal. To illustrate my concern further, let's revisit the prison yard scenario. So we assume that the available evidence suggested that would entitled us to have a degree of belief of 0.99 about Jimmy's involvement in the premeditated attack on a guard. Now, suppose the weight of evidence has been optimized in this case and the jury deems it suitable for submission. Factors such as the high cost of additional evidence and the absence of further potential evidence that could significantly change the probability of guilt are taken into account. According to Nance's super theory, the burden of proof, the fact finder should base their decision on the probabilistic strength of the available evidence. Therefore, since the evidence arguably meets the threshold for beyond a reasonable doubt, Jimmy would be found guilty. However, if the cost of evidence or additional evidence were lower, or if there were additional potential evidence that could substantially change the probability of Jimmy's guilt, the evidence might not have been deemed sufficient to determine Jimmy's guilt. Thus, whether the available evidence is sufficient to declare Jimmy's guilty would depend on pragmatic factors unrelated to the nature of the evidence itself. From an epistemic standpoint, I find this unsatisfactory. The question of Jimmy's guilt should be answered based on the evidence, should be answered on the basis of the evidence inherent nature, not pragmatic considerations that have nothing to do with the evidence at one's disposal. Now, I don't know if I convince you, but in this final part of my talk, I will attempt to convince you that the fact that Nance's endeavor to incorporate the weight of evidence while maintaining a probabilistic interpretation of standards of proof fails short of, from an epistemic standpoint, shouldn't surprise us, since any effort to account for Keynesian weight is inherently doomed to fail from a epistemic perspective. This is because Keynes' notion of the weight of evidence is simply not a well-conceived notion to begin with, despite all that has been said about it. And that is partly why Keynes himself struggled with it. In other words, the idea that we can and should account for the amount of evidence, available evidence supporting a holistic judgment is, in my view, flawed from the outset. So instead, as I will argue, the probabilist recognition that the posterior probability assigned to hypothesis based on the available evidence fails to capture something significant about the nature of the evidence, of that evidence, is merely a symptom of the probabilist's own dissatisfaction with probabilism. So, together with Gardiner, I think that the relevant alternative theory can yield a better framework for modeling legal standards. Unlike legal probabilism, this framework can explain and justify the discomfort that we're making decisions based on probabilistic stress of the evidence, where the evidence seems, the weight seems too slight. So let me turn to that. So relevant alternative theory was first developed as an account of knowledge. Let me go through a very quick example by dress, because it's often used to motivate this account. So you take your son to the zoo, see several zebras, and when questioned by your son, tell him they are zebras. You know they're zebras? Well, most of us would have little hesitation saying that we did know this. We know what zebras look like, and besides, this is the city zoo, and the animals are independently marked zebras. Yet something being a zebra implies that it is not a mule, and in particular, not a mule cleverly disguised by the zoo authorities to look like a zebra. Do you know that these animals are not mules cleverly disguised by the zoo authorities to look like zebras? No, you don't. Since you lack the capacity to distinguish zebras from cleverly disguised mules, and so your evidence cannot rule out this error of possibility. However, it seems reasonable to regard this possibility as too outlandish to be relevant. In ordinary cases, this remote possibility is not relevant to whether you know that the animal is a zebra. However, depending on your knowledge about animals, you may be unable to rule out other less outlandish error possibilities. For instance, suppose you can discriminate zebras from from most other animals, such as camels and deers, but not from unusual animals such as okapis or zebrae. Since zoos typically include such animals, the okapi and zebra possibilities are relevant. Given the relevant error possibility, in this case, you do not know that the animal is a zebra. The evidence available to you cannot rule out relevant possibilities. By the way, a donkey is a zebra mixed with a donkey, and that's also a zebra. There's many others. All this suggests the following account of knowledge. S knows that P only if S can rule out relevant alternatives to P. This account has three crucial components: alternatives, relevance, and ruling out. An alternative, also called an error possibility, is a proposition that conflicts with the belief, in this case, because it's an account of knowledge, under consideration. There can be multiple alternatives to P. For example, the objects in question could be disguised mules, an okapi, or a result of visual hallucination. Each of these possibilities has numerous sub-alternatives, for example, a standard okapi or an unusual-looking okapi, which can be further divided into increasingly specific possibilities, sub-possibilities. So generally, alternatives form a branching structure of possibilities. Some alternatives may contradict available evidence, while others may be relevant and can be disregarded. This brings us to the second component, relevance. Relevant alternatives are those error possibilities that cannot be properly ignored. Now, characterizing relevance is pretty contentious. However, according to Gardiner, we have some implicit graph for which alternatives are relevant for knowledge attributions. The possibility that the animal is a disguised mule can, in ordinary circumstances, be properly ignored. It is outlandish. The possibility that the animal is an okapi cannot be properly ignored. To know that the animal is a zebra, person must be able to rule out this possibility. The final component is the notion of ruling out. To rule out an error possibility, one has to have evidence that discriminates it from that error possibility. So in other words, the evidence must be sensitive to the error possibilities obtaining. Were the error possibility true, the evidence would reflect it. For instance, to know that the animals in the zoo are zebras, you need evidence differentiating it from an okapi, such as noticing torso stripes that are usually absent in cats. However, it is of course possible that the animal could be an okapi with abnormal coloring, and the evidence might not rule out this possibility. Still, this alternative can usually be properly ignored. Hence, as Gardiner notes, from a strict point of view, error possibilities are addressed rather than eliminated, rather than completely ruled out, since there will always be some remote error sub-possibilities that remain consistent with the evidence. Okay, so evidence that rules out error possibilities may very increase the probability of a claim in some cases. However, as Gardiner notes, limiting error possibilities and probabilistic reasonings can diverge, sometimes significantly. For instance, there can be cases in which evidence addresses many error possibilities, but fails to significantly affect evidential balance. This is a hypothetical case. Consider, from Gardiner, consider masterful crime fiction before the big reveal. The reader receives many suggestive clues, but nonetheless, the perpetrator is far from obvious. There are three main suspects. If the butler did it, the murder must have occurred before 3 p.m. So the corpse must have been in a drawing room when the son entered to collect his jacket. How did he fail to notice? It might have been the dairymaid, but only if the farm boy is lying or confused about where she was in the afternoon, and only if the deceased accepted a drink from her. But why would he do that? Or it could have been the street. The many pieces of evidence chop their possibilities into tantalizing sub-alternatives. Some are eliminated by the evidence, such as the sub-alternative where the dairymaid is the killer, yet the farm boy's report is accurate. Others too fanciful and not be taken seriously, such as the chef that secret treatment from the villagers since birth. Other possibilities remain not ruled out, yet not to a lunch, such as that she is the killer and the farm boy is covering for her. An ideal mystery novel might have a few competing hypotheses that are approximately balanced. So in this case, each hypothesis, you've limited lots of error possibilities, but the probability hasn't been affected. It's still 1/3, so that's the idea. But of course, there can also be cases in which the evidence makes a claim extremely likely, and yet it does not rule out relevant error possibilities. Consider, for instance, the Prigioniera practical case. The evidence makes the claim that, if you are happy with that, that Jimmy participated in a premeditated attack on a guard extremely likely, and yet it does not address a relevant error possibility. Namely, that Jimmy was the one prisoner standing against the wall refusing to participate. So Gardiner argues that the relevant alternative framework can elucidate the three legal standards of proof. In this framework, each standard corresponds to addressing varying degrees of remoteness in error possibilities. Preponderance of evidence requires addressing significant error possibilities. Clear and convincing evidence demands addressing remote possibilities far beyond a reasonable doubt necessitates addressing all reasonable alternatives. The overall framework then adapts the relevant alternatives to account of knowledge, and instead proposes a relevant alternative condition on legal standards of proof. And claim P is no longer a belief, so we shouldn't think it's not. So the object is no longer the belief; it's an assertion, or anyway. So clearly, Gardiner's framework is very schematic and leaves open the answer to some admittedly contentious and difficult questions. In particular, what makes some error probabilities remote and others crucified? What determines the location of the three thresholds of relevance? These questions are very much open to debate and don't have an easy answer. Nonetheless, like Gardiner, I believe we shouldn't rush to dismiss this framework simply because these are difficult questions. We can discuss this later if you want. But for now, I want to move to another question. One might be tempted to consider the possibility that the relevant alternative framework may help illuminate Keynesian weight after all. The idea would be to utilize the framework to model Keynesian weight as suggested by Gardiner himself in one of her papers. However, one should resist such citation. Gardiner's relevant alternative framework for understanding legal standards proof has nothing to do with Keynes' infamous notion of weight of evidence. Yet, you'll notice that under this framework, the urge to quantify the amount of the available evidence, its weight, independently of the error possibilities that it moves out, seems to magically vanish. And that's why ultimately I don't buy into the idea that the weight of evidence is a well-conceived epistemic notion to begin with, that we should be chasing after. In my view, the various everlasting attempts to grapple with something like what Keynes had in mind with this notion of the weight of evidence of an argument are merely a symptom of a general dissatisfaction with probabilism. Ironically, one of them shared amongst probabilists themselves. And this brings us to the role of probability in warranted claims. According to the probabilists, the epistemic role of probability is to capture degrees of belief or support about claims. However, from the perspective of the relevant alternative framework, what matters for warranted claims is the extent to which the evidence is able to rule out relevant error possibilities. Hence, under this framework, if there is a rule of probability in warranting claims, that rule cannot be the one envisioned by the probabilist. Thus, embracing the relevant alternative framework for understanding epistemic justification means that there is no role left for probability in warranting claims? No, not at all. recall that one of the crucial components of the relevant conditions framework is the notion of ruling out. To rule out an error possibility, one needs evidence that discriminates the claim under consideration from that error possibility. In other words, the evidence must be sensitive to the error possibilities obtained. Were the error possibility true, the evidence would reflect it. Clearly, one way for the evidence to be sensitive to the error possibility obtaining is if the evidence allows us to logically falsify the error possibility. And for that to happen, the evidence must be logically incompatible with the error possibility. However, it's uncommon for interesting scientific hypotheses such as claims about mechanism and causal generation to be logically falsifiable. And this is where probability can often play a crucial role. According to Deborah Mayo's severe testing view, probability comes into play in scientific context to assess and control how capable methods are at uncovering and avoiding erroneous interpretations of data. Under the severe testing view, a claim is warranted just in case it has been severely tested. And a claim has been severely tested just in case it has been subject to and passes the test that probably would have found flaws, whether present, or to put in other terms, just in case it is a very low probability that data obtained by the test would have accorded so well with H were H false. The role of probability under this view is to quantify how severely a claim has been tested. And this is a completely different role from that of quantifying how probable a claim is. It is worth mentioning at this point that despite being statistical in nature, DNA evidence is widely accepted in courts. As Anna Fisher remarked, DNA evidence first surfaced in American courtrooms in the 1980s and has since emerged as the most important forensic scientific breakthrough of the 20th century, leading to numerous convictions and hundreds of post-convictions exoneration. DNA testing was depicted by one court as the single greatest advance in the search for truth since the advent of cross-examination, and has been analogized to the finger of God. DNA evidence is currently almost universally accepted in both federal and state courts. Now, the relevant alternative framework stands of proof can potentially explain and justify this exception to courts' general resistance to statistical evidence. I say potentially because, as mentioned earlier, characterizing relevance, which will determine which error possibilities should be considered remote or close, is contentious. While I have some opinions on that, I'm not ready to commit to an exact characterization yet. For instance, let's imagine a scenario involving cold hit DNA, where DNA evidence is the sole basis for identification and was obtained without prior suspicion. In other words, the DNA was found at the crime scene and matched against a database, leading to the identification of a suspect, call them A. Suppose further that, given the location of the DNA evidence at the crime scene, it's certain that it belongs to the person who committed the crime, and that there is no risk of a false positive match, so no risk of an erroneous match due to possible error in the collection or handling of the samples, etc. And now, in this case, the court decides to convict A on the basis of this evidence. So the question is, had they not been guilty, would they have still been convicted? According to Anna Fisher, well, in fact, had they not been guilty by the DNA evidence, nonetheless matched his DNA, we would have still convicted him. But this is a different counterfactual, where it invites us to travel to a different possible world. The counterfactual that is relevant here is the one we began with, where there is considerable pressure to answer in the negative. Had it not been A, we wouldn't have found a DNA sample matching A's DNA at the crime scene. The reason that this is the relevant counterfactual is rooted in possible world talk. According to the dominant view in the semantics of counterfactuals, we are to relate the counterfactuals consequent in the possible world, the worlds closest to the actual world in which antecedent is true. There is considerable intuitive pressure to think that a possible world in which A is innocent, and yet the DNA sample matches his DNA is further away from the actual world. That is a world in which A is innocent and no matching DNA sample is found at the crime scene. If this is true, then in the DNA case, unlike other statistical evidence cases, sensitivity is satisfied. So if then efficient situations are right, then the relevance framework can both explain and justify the use of DNA statistical evidence in trials. It is worth mentioning that Deborah Mayo also seems to share Anna Fisher's intuitions as far as what the relevant counterfactual is supposed to be in this case. But I haven't had the chance to ask her exactly what she thinks, so I'm not really sure what to make of this yet. And I'm more than happy to hear any thoughts you might have about this case, because I do find it a bit confusing. So, moving on, nearly the end. Okay, so the debate concerning the role of probability in inference is, as I mentioned before, at the heart of what the statistics was. And and alongside Gardiner, I also see intriguing parallels between severe testing and the relevant autonomy framework, and a close integration of these approaches could not only benefit all involved, but also provide further insight into the debate concerning the role of probability in inference. In particular, in this talk, I try to convince you that the common intuition that probabilism can survive as long as we can also account for something like what Keynes had in mind with this notion of weight of evidence is mistaken, since the weight of an evidence is not a well-conceived notion, epistemic notion to begin with. However, what we should take that intuition to show is that if probability has a role to play in an account of epistemic justification, that role is not the one envisioned under probabilism. And so if we're looking for the satisfactory account of epistemic justification, we should look elsewhere. I think Gardiner's relevant autonomy framework is a promising alternative and does leave room for probability to play a role in the assessment of how capable methods are uncovering and avoiding erroneous interpretations of data. Hence, to conclude, if even a fraction of the effort that has been spent over the many years on grappling with Keynes' notion of the weight of evidence were redirected towards tackling some of the contentious questions raised by Gardiner's framework, I think it would be a step in the right direction. Okay, I'm done. Thank you.
So we'll take a 2-minute break, and then we'll have half an hour for the day.
Hi, Sandy, how you doing?